Honors, I'm Sam Hudson for the appellant Robert Joe Whittenburg, and I would like to reserve 5 minutes for possible rebuttal, please. So what I would like to do today, I'd raised 7 issues on appeal, and the state's correct in its reply brief that some of those, when I got to analyzing them in the body of my brief, kind of got combined with each other. The first 2, issues 1 and 2, are sufficiency of evidence issues with respect to the 2 victims. And for purposes of my oral argument today, I will refer to the victims as girlfriend and mother because they're Deidre Lawrence, the girlfriend, and Deanna Lawrence, the mother of the girlfriend. During the trial, those 2 names were erroneously interchanged numerous times, and so due to the similarity in the names, I'll just refer to the girlfriend and mother. As the court's well aware, Mr. Whittenburg was convicted of first-degree homicide with respect to girlfriend and mother. And the whole issue, the primary issue raised by the defense during the trial of this matter and what later became issues with jury deliberation was the issue of premeditation and the state's ability to establish that beyond a reasonable doubt. This was for lack of a better word, a very brutal homicide, double homicide involving a fireman's axe. And so as the proof would end up, there were essentially no eyewitnesses to this incident. The proof established that there were 3 people in a home on an evening on November 29th of 2017. By November 30th, it was established that 2 of them had been chopped up with an axe, and Mr. Robert Joe Whittenburg was barely hanging on to his life after having tried to take his own life. So the proof at trial wasn't necessarily focused so much on whether Mr. Whittenburg did in fact kill the 2 women. It was the state of mind behind what happened. And so for that reason, I'll go a little bit into the facts that were established at trial. The facts, which were not really disputed by any side, were that Mr. Whittenburg lived in this home with his girlfriend's mother, and the mother's boyfriend. The mother's boyfriend was not present when this occurred. He was on the road working. And so the proof established that leading up to November 29th, the evening of that day, is that Mr. Whittenburg and his girlfriend were basically getting along. They kissed each other before he went to work. There had been an argument on the 28th regarding some names on an envelope that the girlfriend had found. That resolved itself on the 28th. Mr. Whittenburg went to work the whole day of the 29th. By all accounts, he acted normal. He came home, talked with the neighbor next door, acted normal. He went back home into the residence, and no one seen or heard from Mr. Whittenburg or the mother or girlfriend after the afternoon of November 29th. What the unrefuted evidence established through Mr. Whittenburg was that girlfriend had again became upset over these names on an envelope that she had found. She had punched Mr. Whittenburg in the mouth, and that she had thrown an ashtray at him and missing him. After that, Mr. Whittenburg's memory of the event is blank. Now, I see Justice Holloway's reaction, and that was not uncommon among some of the other jurors I've been before in this. And so what you look at, if you don't believe Mr. Whittenburg's testimony that he does not remember, then you're basically left with nothing more than 2 women were killed, and they were chopped up with an axe. But
what about the prior threats, though, Mr. Hudson?
I'm sorry, Your Honor?
What about the prior threats, threats from the defendant to harm his wife? I mean, that would be relevant for premeditation, would it not?
So I think it could be. In this particular case, I don't think that it was, because the only evidence of that came from the boyfriend. The boyfriend could not specify how far prior in time those threats had been made. The boyfriend admitted that Mr. Whittenburg said those based on his own observation with no actual intent of harming his girlfriend. It was more out of a frustration after they had been in an argument or something. And I think the testimony was, I'm going to have to kill her. And moved on and went on about his way. He didn't say anything about how he was going to kill her, when he was going to kill her, or whether he really had any intent. And the boyfriend admitted that he certainly didn't see any actual intent in that. It was the fact that he had just said that out of frustration. We don't even know how far before this incident occurred that he said that, because the testimony also established that the girlfriend would very often fight with Mr. Whittenburg, and that Mr. Whittenburg was never the aggressor. So what we have is we have a killing. Mr. Whittenburg has reluctantly not challenged that, but we don't know, based on the evidence introduced at trial, if that killing or those killings were the result of premeditation and intent, simply the knowing killing of another, or whether it was in the state of passion produced by adequate provocation to lead a reasonable person to act unreasonably. We just don't know.
Wasn't there some evidence about his locking the door?
There was evidence that he locked the door. He testified that he locked the door after he came back from walking the dog. And he also testified that they kept that door locked when they were home, the same reason as the fireman's axe was kept on the inside of the kitchen door, because there were unsavory characters in and around the house and the neighborhood. So there was evidence that he locked the door, but there was also evidence, which was unrefuted, that that's what they did routinely.
What about the evidence that there appeared to be a chase throughout the house? So there's a blood trail going throughout the house. Could a reasonable jury infer from that the victim was being chased? She had already been attacked. Blood had been drawn. She's trying to escape. Wouldn't that, if the jury were to draw that inference reasonably, wouldn't that support a finding of premeditation?
If they reasonably drew it, but there was no...
on our standard of review, all reasonable inferences
Sure.
go in favor of the state's verdict. So if the jury could reasonably find it, doesn't that provide some evidence of premeditation?
Based on how you couched it, Your Honor, but I would submit that the evidence established only, not that the chase occurred through the house, it merely established that there was some blood of girlfriend on a countertop or a tabletop in the living room, but she was actually, her body was found probably about 25 feet away near the kitchen door. There was no trail of blood. There was simply one drop of blood on a coffee table in the living room, and then she was found near the door of the kitchen. So if you look at the evidence that was presented, not what the state's theory was, because the state's theory without any evidence was that there was some chase. There's really no evidence of that other than a blood drop here and the body being found over here. You could also take it that perhaps the mother and the girlfriend got in a fight with each other, which the evidence established that they were prone to do. It sometimes became physical. That was unrefuted evidence.
What about the evidence of repeated blows? So our case law would say that evidence of repeated blows is a fact, not the only fact, but a fact from which a jury could infer premeditation. What about that?
Well, Your Honor, and so in that case, my argument was, and it still is, that's basically the only evidence you have of premeditation. And the case law also says that repeated blows in and of themselves are not sufficient to find premeditation. I argued that in the jury instruction, which I won't get into for purposes of this brief. But I believe that when you take the evidence, the unrefuted evidence that was presented to the jury, that's what the state focused on, was the repeated blows. Everything else was theoretical without any evidentiary support.
Well, it was circumstantial, and the door locked, the blood, wherever it was located, the repeated blows, the prior threats. And assuming that the jury was properly instructed as to premeditation, wasn't the jury, and viewed in light most favorable to the state, isn't the jury's verdict supported by those circumstantial facts?
My position, Your Honor, is that the facts do not lead to a reasonable inference that there was premeditation. The facts that were presented to the jury certainly lead to a direct conclusion that two women were murdered, probably brutally. It's the intent, the mindset behind Mr. Whittenburg at the time that happened, I think. And I don't know that I don't believe there is sufficient evidence for a reasonable juror to infer premeditation based off those. With the court's permission, I will switch those.
Which your position is basically that it's second degree, not that it's voluntary since he didn't testify.
At worst, second degree, possibly even voluntary. I think there is certainly sufficient proof in the record to establish voluntary manslaughter in that Deidre punched him in the mouth and threw an ashtray at him. Now,
But voluntary manslaughter still requires an intentional or knowing killing. So, I mean, are you conceding the fact of an intentional killing?
I'm conceding the fact that there was a killing, Your Honor.
Okay, fair enough.
That's what I'll concede. Moving in, though, to my, actually, it's my fifth and to some extent the sixth and seventh points. And that was the issue that was later raised after the jury went to deliberate. If the court reads the transcript, you can see that I harped on the lack of evidence for premeditation throughout my closing argument and during the case in chief. The jury deliberated 4 hours over a double axe murder when the justices here are having pretty clear acceptance of the fact that Mr. Whittenburg intentionally murdered these two women. So I would point to the 4-hour deliberation as adequate proof that the jury was at least considering the issue of premeditation and if there was sufficient evidence. That fact is buttressed by the fact that about 2 hours into deliberations, the court officer in charge of the jury comes back to the judge and admits that he has had a discussion with 3 or 4, he's not quite sure how many, jurors about them asking him the definition of premeditation. Mind you, this occurs while about 3 other jurors are out on a smoke break. So at that point, the trial court has reliable and admissible evidence of extrajudicial statements. I briefed it in my brief as a matter of separation. The state says it's extrajudicial evidence. I think the analysis actually kind of is the same regardless of whether it's jury separation or extrajudicial communication. The question is, did they receive extrajudicial communication and did it prejudice them? And so we know that they did. The chief deputy admitted to that. It was his first day on the job, or his first trial on the job as a court officer. So what happened then is the judge brings all the jurors back in. Now at that point, when the court receives this reliable evidence, it then turns to the state. The burden shifts to the state to show that those jurors were not influenced and that Mr. Whittenburg wasn't prejudiced. What happens is, I'm the only one that questions that court officer. The state doesn't question him at all. And I asked the court...
But Mr. Hudson, I mean, isn't it the more important point, though, that the court questioned the jurors?
The court did not question the jurors.
He didn't question them collectively?
Yes.
And then reminded them you need to follow the court's instructions, and then got their agreement that they would follow only the court's instructions?
That perhaps, Your Honor.
Tell me. I mean, that's what I took. So
what happened from the defense's perspective is the judge brought all the jurors back in. The first thing he did was admonish them for taking smoke breaks during deliberations and declared blanket declaration that there will be no more smoke breaks until we reach a verdict.
I see that as a little bit of a different issue.
Well,
so let's go back to as you claim, the separation here.
Right.
So I have the trial court establishing the fact of a violation through your examination and the officer's testimony. But I also have the trial court asking everyone, can you follow my instructions? Gets an affirmative response, I think, but you'll hold me to the record. Asks counsel, do you want individual polling? Counsel said no. No?
I specifically asked for individual voir dire.
You specifically asked for individual voir dire and he turned it down?
I was initially denied. And so the reason I was pointing out that the judge declared no smoke break is because that's how this interaction with the jury began. So a blanket prohibition against smoke breaks, then told them that they had received extrajudicial communication from the court officer. It was improper. They shouldn't listen to him. Then asked them collectively, if everyone understood that, and if any of them were affected by that officer's statements.
And could follow the law.
Maybe. I'd have to go back
Okay,
and
sure.
you may be looking at the transcript and you may have said that. But the bottom line is it happened after the judge kind of chastised them all for taking smoke breaks. And so I think the effect of a blanket question to the jurors at that point, whether it had affected them or not, maybe put a damper on their perhaps tendency to say, yes, I've been affected by it, because at that point the whole jury's been chastised for people taking smoke breaks. And I specifically asked for individual voir dire, initially was denied. After the jury retired, the judge said, well, you can ask them after the jury reaches a verdict, which we didn't go back and do that. So that's where we were.
And did you call any juror at all in the motion for new trial?
Tried. I did not receive any calls back.
Okay.
I think I may have used all my time, Your Honor.
Thank you.
All right, Mr. Douglas?
Morning, Your Honor. I think it's still morning. May it please the court.
5 minutes till it's noon, so you're good.
Just in time. Davey Douglas on behalf of the state, and we would ask this court to affirm the defendant's 2 convictions for first-degree murder because the evidence is sufficient to sustain those convictions, and the trial court's handling of the extrajudicial communication with the jury was proper, and there was not a need for mistrial here. But turning first to the sufficiency of the evidence, the state was not required to prove every single thing that went on in that house between the 2 victims and the defendant. But what the state did present was plenty of circumstantial evidence from which, and again, viewing the light in that most favorable to the state on appeal, a rational trier of fact could have found that the defendant acted with premeditation. The first thing we have are the threats that the defendant had made, where Deanna's boyfriend had overheard him say he had threatened to kill the victim. He said he was going to kill the victim. And the jury was able to hear sort of the circumstances surrounding that threat, but it was important that it was a threat that was made. And it doesn't matter where in time it was made, it's still relevant and indicative of sort of that intent and premeditation that he's making the threat. And then we get to the night of the killings, where we have...
Are you saying that it's irrelevant because of the standard of review, or are you saying that it's irrelevant for 404B balancing? Why is it irrelevant?
Sorry, I was saying relevant, but I believe what I meant is just it's indicative of...
What I heard you say, and I'm sorry, please excuse me, is that the timing of the statement was irrelevant. That's what I heard you say.
Yes, it was relevant just it was relevant of the intent of premeditation, just to show that he's, before this killing happens, he's at least contemplating taking the victim's life.
When were the threats made?
I don't know exactly when. Jeff Seals testified about the threats, and he could not recall the specific date that they were made, but it was at some point before the killings.
Was there a 404B hearing that came in with, that allowed this evidence to come in?
I know that there was a 404B hearing, and I apologize off the top of my head. I don't know if it was specifically for this evidence.
That's okay, that's why I'm asking. I don't remember either.
But there was a 404, I know there was a 404B hearing. But this threat is just one of the many pieces of circumstantial evidence to consider. We get then to the locked door, which shows that the defendant was acting with the intent to keep the victims in the house. And then we've got the weapon that he procured. There's also no proof that the victims were armed. And you have the defendant striking repeated blows against unarmed victims. And we've got the evidence of Deidre's blood. You found some of the blood in the living room, and then there was more in the kitchen, which a rational trier of fact could have found was indicative of the attack beginning in the living room and then continuing into the kitchen, where the defendant, over the course of that time, struck multiple blows. And then what we have after the killings are the defendant, who is an admittedly trained EMT, not seeking to render any aid to the victims or seeking any help for them. And when you take all of these pieces of evidence together, that's certainly enough for a rational trier of fact to find that the defendant acted with premeditation. And what the jury's verdict shows is that, as it was entitled to do, it rejected the defendant's version of the events that led to the killing. That was the only source of the proof between the alleged fight between the two victims, or between Deirdre hitting the defendant with an ashtray. There was nothing to show that he had wounds that would have corroborated his claim to be hit with an ashtray. And again, the jury was absolutely entitled to reject the defendant's version of events, and that's what its verdict shows. And that evidence is sufficient to sustain the defendant's convictions for first-degree premeditated murder. And turning then to the issue with the jury, with the jury and the communication with the bailiff, the trial court here followed the proper procedures in that as soon as it was alerted to this communication between the court officer and the jury, it had a hearing on the matter where the officer explained that he walked in thinking the jury was simply going to ask him for snacks. And they asked him, what's the definition of premeditation? He provided a short answer and then said, I think you're going to need to talk to them about that, directing the jury back to the attorneys and the trial court. And both parties had ample opportunity to question the court officer. The trial court questioned him repeatedly, and then the trial court did ask the jury. It cautioned them repeatedly not to listen to the deputy's definition of premeditation. It advised the jury that the only source of the law was the instructions that the trial court provided. And it asked the jury if anybody would have a problem disregarding the deputy's definition of premeditation and following the court's instruction. And what we don't have is an affirmative recognition in the transcript that each juror said yes, or an indication that there was a head nod. What we have is the trial court asking the question and then responding and moving on, which indicates at least there was no negative response. There was no juror that indicated, I will have trouble following the law, and I would have trouble disregarding the deputy's definition of premeditation.
General, your friend on the other side suggests that he was denied his ability to conduct individual examination of the jurors at that point. Is that your reading also?
Yes, Your Honor, it is.
Okay, so how does, I think at least at that point where either there's been improper separation or improper communication, I think the law requires at that point that both sides, both the state and the defendant, be given the opportunity to conduct individual examination where the trial court's collective examination may be insufficient. So what do we make of that, that the trial court denied the defendant the ability to make individual inquiry?
I don't know that there's always the automatic entitlement to individually question the jurors. I think it is significant, though, that the trial court afforded the defendant the opportunity to question the jurors after the verdict. And we don't have anything in the record indicating that these questions were asked, or more importantly, indicating that anything affected the jury's deliberations or verdict. So we don't have anything that shows prejudice. And what we do have, though, is the trial court sort of exercising its discretion and having collectively questioned the jurors, made its determination that that the court could continue and let the jury continue to deliberate. And we also have the pretty high standard for a mistrial here. A mistrial is appropriate when there's a manifest necessity. And here the trial court got repeated indications from the jury that it was not going to consider the definition of premeditation that the deputy provided. You have indications that the jury would consider only the law that the trial court provided. And so that is not something that rises to the level of a manifest necessity warranting a mistrial. There's enough here from just the transcripts alone for this court to look at it and to conclude that the trial court did not abuse its discretion with the very specific way that it handled this. And again, there was that opportunity to question the jurors, at least after the verdict, that we don't have anything in the record to show that that was borne out. And again, it's one of the most important things here is the jury's repeated indications to the trial court that it was going to disregard that definition and that it would only consider the definition the trial court gave. And I know there's been some discussion sort of about the length of the jury's deliberations. It's not entirely clear from the record when the jury actually started deliberating. They were released at 11:30, but then there was some discussion about whether they went to lunch, which could have happened in between the hours of 11:30 and 1:47 when the court learned about the extrajudicial communication. But the length of a jury's deliberations, it's not indicative of the validity of the verdict. It's not something that shows any prejudice based on the trial court's chosen remedy of repeatedly instructing the jury rather than granting a mistrial.
Were there any questions or any other evidence in the record after the incident with the bailiff that showed the jury was still wrestling with this issue, other issue?
So there was one juror question, or there was, I believe there were potentially two. The record's a little unclear about one. There was an issue with getting the easel into the jury room where it's not clear why the jury wanted that. And then they asked a second question saying they needed gloves to handle the evidence. It's not clear why they requested the gloves or what evidence they wanted to handle, but we don't have anything specific saying that they were struggling with, say, premeditation or any of the other legal questions. We just have the request for gloves to look at the evidence. And that was something where the trial court, I believe, did send the gloves back to the jury. But based, again, on the ample circumstantial evidence here, all of the circumstantial evidence was what the jury could take and consider and find premeditation. And it was proper for the trial court to allow the jury to keep deliberating. And so we would ask this court, unless there are any further questions.
Your friend on the other side didn't get to talk about the denial of the smoke breaks, and I assume the implication is somehow that rushed the verdict. But do you want to address that?
In fact, that is the argument, actually, is that it rushed the verdict. So what's the state's response?
Yes, that there is simply no evidence here that the smoke breaks rushed any type of deliberation. I think I would slightly disagree with the characterization that the first thing the trial court said was, I'm removing smoke breaks. The first thing the trial court said was it called Officer McGee to the stand and started questioning him. It was sort of after the court was admonishing the jury to only listen to its instructions and its definitions of the law that it said, and we're not going to allow any of these smoke breaks. There's nothing in the record to indicate that the jury wanted to take a smoke break and that they were denied that opportunity, and there is just simply nothing in the record to indicate that there was any issue with the jury that caused them to rush through or reach a verdict they would not have otherwise reached but for the elimination of the smoke breaks. And it's something that both the state and the defendant agree. Tennessee courts have not really seemed to address this issue, but other courts that have found that there's no error in the trial court sort of exercising its discretion to control when jurors smoke. And what we have here too is the court later backing off of the elimination of the smoke break. It said that it would allow the jury to take a break when it thought it was warranted. And then we don't have anything in the record to show that the jury was ever denied the opportunity or that the smoke break discussion had any impact on the verdict. And so we just don't have anything here to show that the trial court committed error. And unless there are further questions, we would ask this court to affirm the defendant's convictions. Thank you.
Mr. Hudson?
Thank you, Your Honor. Just briefly, and again, I'll focus on the jury instructions. My recollection of the transcript was after Officer McGee was questioned, the judge brought the jurors out, and after just briefly acknowledging that some extrajudicial communication had occurred, chastised them about the smoking. Now, the court did later say on the record that I will allow the jurors to have a smoke break when I deem it necessary, but the jurors had already gone back into the jury room to deliberate at that time, and I asked the judge at that time to let them know that he had changed his mind, and he never did. So for 2 hours, the jurors deliberated under the assumption that they were not going to get any more smoke breaks until they reached a deliberation or a verdict.
Was the judge concerned that the problem that they had with the officer occurred during the smoke break? I mean, did he express that concern?
This was such a odd trial. It was the very first trial in our judicial district after the COVID prohibition. And it also occurred in Franklin County. It was a Bledsoe County case. We took the whole court to another county for a number of reasons. The courtroom was bigger. There was a huge 127-yard sale going on in Bledsoe County. So it was really odd. The court, by the time, although the record is not clear, by the time we got to this issue of the smoke break, there had been some other extraneous issues that apparently were not captured on the record that had frustrated everyone by that point. So this was kind of the cherry on top, that a brand new court officer had talked with the jurors while, some of them were out on smoke break. And I think that was just the judge's knee-jerk reaction to addressing the issue, prohibiting smoke breaks, and then coming back and addressing the issue of the improper and extrajudicial communication.
So, Mr. Hudson, let me ask you this. I wonder if you're asking us to take a whole lot on faith here. So typically, what we would do in claims like this to look to prejudice is that there would have been some questioning of some jurors somewhere. Maybe not necessarily right after the trial, but certainly in the motion for new trial or otherwise. And at that opportunity, then we would have a record that we could look to with a juror saying, yeah, I thought I was rushed. I thought I had to reach a verdict. I'd never get out of there to take a smoke break, and I would have liked to have deliberated further, for example. Or, the officers, I know I told the court one thing, but he was pretty mad at us, and I wasn't about to tell him that the officer had goofed, but I was kind of relying upon what the officer had said. We don't have any of that here, and it strikes me that you're asking us to take a pretty big leap of faith based upon the record that we have. So how do we make a finding of prejudice if none of that information is contained in the record?
Well, I think what the case law suggests, Your Honor, is when the court does not have reliable evidence on whether the individual jurors were effect, is that the court almost always has remanded the case, at least, if not for a mistrial, for the very limited purpose of questioning those jurors. The burden shifts to the state once this extrajudicial communication is established. So I understand the court's question, why did you, as a defense attorney, not present these witnesses? That's not here, but the reality is it's the state's burden then to establish beyond a reasonable doubt that the jurors were not unduly prejudiced.
Does that follow even at the motion for new trial where it's your burden?
I'm sorry, Your Honor.
So does that follow even at the motion for new trial where it's generally your burden to show entitlement to a new trial?
I believe it follows regardless of what happens at the motion for new trial, Your Honor. And so even at the motion for new trial, if I had not been able to procure juror statements, the burden would still be on the state to show beyond a reasonable doubt that there was not improper influence on the jurors. And so at a very minimum, I think the court is required to remand this case to the trial court for determination of that very issue, an individual voir dire of the jurors.
All right, thanks, Mr. Hudson. All right, anything else? Great. We'll be in recess until 1:30.